mentioned, this is our webinar today, everything you need to know about sponsoring care workers. This is sort of an introduction session for employers. We'll be looking at how to sponsor migrant workers, and particularly foreign workers who are looking to work in the care or social work profession. My name is Nina. I am the senior paralegal here at Clarendon Park Chambers. A little bit about our organization, if you haven't heard of us before. We are a barristers' chambers in Leicester, also working in London, that mainly focuses on immigration. So we have we deal with all sorts of different kinds of cases, whether that be personal immigration cases or human rights cases. And we also have expertise in business immigration. So today we'll be discussing a bit about business immigration. As many of you know, there have been a lot of changes over the last few years, especially in regards to sponsoring and coming into the UK as a worker on a skilled worker visa. And a lot of this has come about due to Brexit. Today, we're focusing on, in particular, the statement of changes that was released on the 24th of January that implemented changes to the skilled worker route in terms of hiring care workers under the skilled worker route. Now, this was not something that was able to be done before, and it's welcomed by many in the health and care sectors because of the fact that there has been a huge need for care and social workers due to both the pandemic and also because of Brexit. So we've identified a few important points to note today for both applicants and also mainly for sponsors. And we sort of package this in a way that hopefully can be easily digested. What's clear is that, you know, things are apt to change. This happens a lot in immigration law and especially in business immigration. So there will be time for questions at the end of the session, and we'll answer them as best we can, obviously. But also a point to note that we have done a number of these kinds of sessions before. And if you would like a bit more information, more sort of in-depth detail on breaking down the routes and the changes that have come into place since 2020 until now, you can check these out on our YouTube channel. I'll provide details of that a little bit later. So with that being said, we're going to move on to the agenda for today's webinar. So today we'll be covering these following topics. Our main aim is to help you understand the basics of sponsorship as an employer and a business, as well as how the system has changed recently. And what the advantages and disadvantages associated with this are. So the agenda is, number one, what is sponsorship? 2, how to become a sponsor, hiring foreign care workers, sponsor duties and compliance, and a Q&A session at the end. During the session, please feel free to put any questions into the chat. Clara will be filling these for now, and we can go over them during our Q&A at the end. If you can keep your mics off until the end, until the Q&A, that will also be very helpful. Thank you. Right, by way of background, as we know, the United Kingdom exited the EU on the 31st of January 2020. The transition period ended on the 31st of December 2020. So from the 1st of January 2021, all EU nationals not already residing in the UK have become subject to immigration control in the same way that other non-UK citizens are. So the new skilled worker route has replaced the previous route, which was called Tier 2. And this route governs how employers are able to recruit and employ overseas workers. The employers who currently employ or wish to employ overseas nationals must hold a sponsor license to validly recruit migrant workers. This is not subject to, this is apart from the hiring of EEA nationals who hold settled or pre-settled status under the EUSS, as in the ones who were living in the UK prior to the 31st of December 2020. Now, on 14th of February 2022, an amendment was made to add care and social workers to the shortage occupation list, but they were not added to the skilled worker occupation. So this will be explained a little bit more in detail in the next slides. But this final point is what we will be focusing on today. Businesses and employers in the UK must make sure that they're complying with the current rules in terms of employing foreign workers and especially care workers. And employers should know how to perform the right to work checks in for their current or future employees. So if there are foreign care workers already in an organization, how the organization should be functioning, or if they're looking to recruit foreign workers, how this works. Okay. So what is sponsorship? There is a high proportion of foreign employment in the UK. Just a note that we don't have the figures yet in terms of 2021, 2022. The ONS is set to update this around April this year. But as you can see from the last statistics, there are 2.31 million non-UK nationals from the EU working in the UK, and 1.34 million non-UK nationals from outside the EU working in the UK. Now, the second figure in particular is set to increase most likely. The first figure may decrease a little bit initially, but there's no reason why EU nationals, just because we have exited the EU, should not be accounted for. They will still make up a large portion of the UK workforce. Moving on to carers. So carers, in terms of care workers in the UK, this is a huge industry. There are almost 7 million carers in the UK, which is 1 in 10 people. This number is rising. And in terms of the economic value of the contribution made by carers in the UK, currently is £119 billion per year. So that's a huge area of employment. And in the next 30 years, it's expected that this number will increase by around 60%. This is largely because of the UK's aging population. The number of people over 85 in the UK is expected to increase by over 50% over the next decade. So it's very clear to see that carers will be a very important, will have a very important role to play in the UK market moving forward. Currently, 84% of care workers are of British nationality. 9% of carers are non-EU nationals and 7% are EU nationals. Again, there has been some fluctuation here in terms of the last year or so because of Brexit, but we also know the large demand that there has been on care services because of COVID and the pandemic. And also there's been a big shortage of care workers because of this as well. Now, the figures here represent both professional carers and also home carers. So this is also something to think about in terms of whether they're working at an organization or as residential carers. So what is sponsorship? So if you have not heard of sponsorship before, I'm sure some of you probably have, but just a sort of quick breakdown of what this is. If you wish to employ a person who is not a settled worker, someone who has the right to work in the UK, or who does not otherwise have immigration permission to work, you need to be authorized by the Home Office, basically. This authorization is known as a sponsor license. And once you have one, as an employer, you'd be known as a sponsor. There's a number of criteria that must be met to be able to be sponsored. So a foreign worker who comes in, if they have a job offer that meets a relevant criteria, they can then make a valid application under the worker or temporary worker routes. The sponsor, the employer, is able to take on this person by assigning a certificate of sponsorship to the worker. And there are sort of two main roles that sponsorship plays in the worker's application for permission to enter or stay in the UK. Applications can be made from within the UK, or it can be bringing in a foreign worker from overseas. So the two main roles is that where relevant, it provides evidence that the worker will fill a genuine vacancy in a skilled occupation and that they'll be paid appropriately. And it also involves a pledge from the sponsor that it accepts all the duties of sponsorship. And those are extensive. So unfortunately, there are a lot of duties that they must comply with as a sponsor. And you must know them quite well to be able to make sure that you don't lose your sponsorship license. So there's an important point in terms of sponsorship that the Home Office loves to drive home. They bring this up anytime they sort of have any sort of talks about bringing in skilled workers or immigration rules. Sponsorship is a privilege, not a right. So this means that those who benefit most directly from employing migrant workers, as in the employers, must play a part in ensuring the migrant immigration system is not abused. They must comply with wider UK law and not behave in a manner that is not conducive to the public good. So essentially, a sponsor does fill sort of the role of an immigration officer to an extent, because they will be checking credentials and things of the migrant worker to make sure that they are also complying with immigration rules. Overseas nationals who apply for permission to enter or stay in the UK to work are eligible, and a trustworthy and licensed employer generally wishes to employ and sponsor them. So those who come from overseas to work must make, it's sort of a way to check that they are actually doing what they say that they are going to be doing, and the sponsor themselves, the employer themselves, are a reliable person. So what are the consequences if you don't comply with these immigration duties? So under the Immigration Nationality and Immigration Act 2006, there's a penalty in terms of breaking immigration control, that if you do employ someone who has not been granted proper leave to remain or enter, then their leave would become invalid in that sense, and there would be a penalty incurred on you for that. Under this, there'd be a civil penalty of up to £20,000 per worker, and this is a starting point. It could actually be a higher fine depending on the compliance, or sorry, non-compliance with the law. And there could also be criminal proceedings that brought against you with a maximum sentence of 5 years imprisonment. So it is quite serious. And they have stressed this many times, the Home Office, to basically say that, granting a sponsor license is not just something that they will do without doing proper checks, without making sure that the business is reliable, and without doing continuing checks and compliance visits throughout the sort of lifespan of sponsorship. That being said, though obviously it is quite a serious thing to take on, there are many advantages of sponsorship. So once an organization acquires a sponsor license, they'll become registered with the Home Office as a sponsor, and they can begin issuing certificates of sponsorship. This means that they can hire overseas skilled talent that will help with their business in terms of growth and operation. They can also continue to employ nationals of other countries that are already in the country following Brexit. So for example, if there are EU nationals who have not gone through the settled or pre-settled status through the EUSS, they can continue to work for employers as long as the employer has the sponsor license. There's obviously a high variety in terms of diversity of talent and ability from abroad. And also it allows them to hire UK international graduates who have completed programs in the UK. Okay, so how to become a sponsor? So this is the big question. What is the process? How do you actually go through it? There's a number of steps for applying. you have to make sure that your business is eligible to hire and has sufficient capacity to take on foreign workers. It doesn't matter if you're a big or a small business, as long as you are very aware of your workforce and you have a dedicated team or person who's able to keep an eye on your foreign workers. This is good enough, but you have to prove it to the Home Office. You also will need to choose a type of license that you're applying for. This will depend on the type of worker you're going for. So obviously in our case, we're looking at skilled workers. So you wouldn't be looking at, for example, maybe charity workers or other individuals, religious visas or things like that. And so, yeah, you'll need to decide who will manage the sponsorship. So again, this is sort of your HR team. So who's going to be taking on the responsibilities to make sure that the workers are in fact complying with their duties, and that you as the employer is also making sure that you're doing the right things in terms of reporting, paying the right salary, etc. Then you would apply online and pay a fee. After you apply, and hopefully after it's been granted, you'll be given a license rating if your application is successful. So you would want an A rating, which means that you are an A-rated sponsor. You don't want to lose this A rating. And once you've been given this, you will be able to start issuing certificates of sponsorship. If you have job openings that are suitable for sponsorship, usually when you apply, you will apply with a role in mind, and you can put this into your application to show that there's genuinely a need for hiring a foreign worker, which will give you more basis of actually being granted the application. This will be valid for 4 years, and you may lose your license if you do not meet the responsibilities as a sponsor. Here's a quick sort of guide from the Home Office that was issued in terms of sort of how you go through the process. And I'm going to be breaking this down a little bit on the next slide. All these slides will be provided, by the way, after the session. So we will give this to you, and I believe we will also post this video on our YouTube channel. So you'll have a chance to sort of review it on there as well if you'd like. So how to become a sponsor for new sponsor application, new sponsor license applications. You will need to have that designated person who is the authorizing officer who will submit the application online and pay the fee. They could be either, your organization could either be a small or a large organization, depending on your turnover, your number of employees, and things like this. The application will be submitted by email along with supporting documents. And there is a very short timeline from submission to providing the supporting documents. So whenever we do this with our customers, our clients, we always make sure that all the documents you would need to submit are ready to go before you actually hit send. So you need to make sure that that's actually been prepared so you don't miss any sort of deadline, because if you do, then things can become very messy. You also need to remember that there's a limit on the attachment size for the emails. And you will also need to sort of go through and make sure that if there are certain documents that you need to provide because of the nature of your organization, for example, let's say you work in a food business, you would need to have approval to show that you've been registered with the Food Standards Agency, or any other sort of body that oversees you as an organization. There's also the option for a priority service. Now, the priority service will process the application much more quickly. And I believe it's meant to be within, I think it's 15 days, whereas the normal application takes around 8 weeks. So it's definitely a lot quicker, but it is an extra £500 that you would be paying. And they only have a limited number of priority service applications per day. They release this in the morning. And if you get it, you get it. If you don't get it, then unfortunately, you just have to go with the normal one. So in terms of the fees, there's always a question people ask us. So for a sponsor license, to submit the application, the fee you would pay for a medium or large organization is £1,476. For small organizations, it's £536. Now, the definition of this is laid out below on the slide. And if you do qualify for this, obviously, then it's good to do that. Now, a point to note is that if the Home Office feels that you are not actually eligible for a small organization sponsorship, then and you've applied as a small organization, then they will not refund you. You'll have to just reapply as a medium or large organization. However, if you apply as a medium or large organization, and actually the Home Office feels that you qualify as a small organization, they will refund you the money and put you as a small organization if you're unsure about where you stand. So it's always good to just, cover yourself and go with a medium to large if you're not sure where you're at. If it's very clear, obviously, that you're definitely a small organization, then that's not a problem. As I mentioned previously, you would, if you want to do a priority service, you would have to pay an extra £500. And in terms of assigning the costs, this can range between £232 and £1,220, depending on the size of your organization and how long you would like to issue the certificate for. So it can be either less than 3 years or more than 3 years. There's also reductions for visas under the short occupation list or health and care visas, which would be relevant to the social and care worker routes. Also need to remember that there's an immigration health surcharge per person of £624 per year. So if you were planning on sponsoring them for, let's say, 5 years, you need to be aware of that, because you would have to take 624 times 5 and add that to the fees that you would be paying. So yes, there are a number of costs that are involved with becoming a sponsor, but in the long run, obviously, it would be, even though it's an initial sort of large payment at the beginning, in the long run, it would obviously be beneficial to the actual organization to have those sponsors coming in and being able to sponsor them, depending on what you need with your organization. So the eligibility requirements for a sponsor license. These are the steps that the Home Office will check when you apply. So the organization must have a genuine UK presence, operating and trading lawfully in the UK. They must be honest, dependable, reliable, not engaging or having engaged in behaviors or actions that are not conducive to the public good. They will also be very careful to check that you are actually capable of carrying out your sponsorship duties in terms of your compliance, that you can offer genuine employment that meets the skill level and salary. This is very important, and we'll talk about salary in a moment, and that you can meet any other eligibility or suitability requirements. So all of this will be reviewed when you make the application, either through a compliance, a pre-certificate compliance check, or through a series of questions that they'll put to you, and you reply through a paper interview. So suitability requirements. This is based on the route that you will be looking to employ the migrant worker under. So under the worker and temporary worker routes, if you are applying for a skilled worker or intercompany worker route, you must make sure that the applicant meets the genuine vacancy, salary, and skill level requirement of those routes. This is specific to what job you're going for. So we'll be looking at care workers in a second to see how that plays out in terms of those things. Each route has route-specific guidance, and there's a lot of it online. There's also information within our previous webinars that we looked at, where we went very much into detail about how this can be broken down depending on the route, depending on the worker, and sort of giving a number of scenarios of how it can play out. So in terms of the skilled worker route, which is technically what the care worker comes under, we'll explain that in a second. The skilled worker route, the general requirements are that there's a genuine vacancy, okay? There is no longer something called a resident labor market test. So when it comes to assessing genuine vacancy, you just need to be able to prove that there's a requirement in your organization for this job holder to perform specific tasks for the job and meet the requirements in terms of the skill level. So make sure that it's appropriate for the business, that you've considered that why this individual in particular is appropriate, what processes you went through to recruit them, to find them, if you posted job advertisements or whatever, how you got there, if they were a recommendation through another organization, correspondence between the two organizations, etc., to show that they were a dependable and good worker. That's why they were, able to actually come through. So all those sorts of things, are ways to prove this, and it can be quite subjective and depending on what the Home Office is looking for. So in terms of the salary, the minimum is 25,600 per year, or the going rate of the job, whichever is higher, but there are exceptions. And there are particular exceptions for the care workers. We'll be going into that in just a second. So the skill level is based on the appendix skilled occupation. You have to find the correct skilled occupation code or SOC code to confirm that the job is eligible. Now, the code for care workers is not technically on the skilled occupation list. However, it's been slotted into the rules because the statement of changes that came about earlier this month. That basically allows jobs either that are in the skilled occupation list or in the shortage occupation list to qualify for applying for a skilled worker visa. So the shortage occupation list. This is a list that is curated by the Home Office that is updated regularly, and they will add and remove jobs from this list depending on what they feel is needed in the job market. So there's been a lot of talk about this for quite some time, I would say, both because of COVID and Brexit, that people have said that obviously the need for healthcare workers in particular needs to be addressed because there's been a huge shortage of this in the UK. So in the changes that came about, they've added that basically the occupation code 6145, which is for care workers and home carers, they've added this into the list of migrant workers that can be sponsored. Now, employers are able to sponsor migrant workers either under the list and appendix skilled occupation or appendix short occupation list. This was not the case before. It had to be under appendix skilled occupation. And then if the code was also in the short occupation list, great for the employer. Now they've changed this to add if it's in either, it's fine. So the salary for jobs under the shortage occupation list is 80% of the going rate. Now, as we saw in the previous slide, the threshold amount is 25,600. 80% of this is 20,480. This is the salary for shortage occupations. So care workers would be able to be sponsored as long as they were getting paid this salary per year, or £10 per hour, £10 per hour, whichever is higher, depending on their hourly rates. So how does it get assessed? What's the system for the Home Office to look into these things? When they are looking at employing a migrant worker and assessing whether or not this person is suitable, they will calculate the applicant's points. So there's a calculation of points under the points-based system, and the applicant must score 70 points total, okay? They will receive a mandatory 50 points as long as they meet the 3 mandatory conditions which they must have, or else their application is not valid. So these 3 things are sponsorship, skill level for the appropriate job, and English language, okay? So if they have those 3 things, in terms of they've been offered a job by an employer who has a sponsor license, who's willing to sponsor them. They have an appropriate skill level for that job, and they have at least a B1 in English. They will have 50 points automatically. The second 20 points will be added based on a number of things, and it can be related to their salary, their education, or importantly in this case, if their job is on the shortage occupation list. If a job is on the shortage occupation list, it is awarded 20 points automatically. It will still need to meet the salary requirements, of course, but they will be given 20 points because the job is on the shortage occupation list, giving them a total of 70 points, which will allow their application to progress. So looking at the mandatory points here, I've listed the rules here in this little table. So if you look in the appendix skilled worker, that's where all the information is in there. But for sponsorship, this is looking at the requirements of genuine vacancy. Okay, the appropriate skill level is based on the SOC code. So in the case for care workers, 6145, and making sure that the job is eligible. In this case, it is because it's on the shortage occupation list. In terms of proving skill level, there isn't a specific sort of professional qualification that you would need to be a care worker, but you still need to be able to show that that person has the appropriate skills to be able to carry out the job. And the English level stands at B1 in terms of the Common European Framework for References, CEFR. Okay, so as I mentioned previously, in terms of the tradable points, so we looked at the mandatory points. You get 50 points just off the back of of making a valid application. The other 20 points is usually done based on salary, and the salary can fluctuate depending on the situation of the actual worker. So the sponsors must pay the applicants either the relevant general threshold or the going rate, subject to permitted reductions, whichever is higher. So as I mentioned, the general threshold, the minimum is 25,600. This is often higher for many of the occupations on the skilled occupations list. But for shortage occupations, because it's 80% of the going rate, it would be £20,480. Okay, they can't be working more than 48 hours a week, though, on that. Okay, great. So first, specifically looking at care workers, the genuine vacancy is obviously the offer of a job. The appropriate skill level, as I mentioned, there's not a formal qualification that's required, but you would still need to prove that they have the relevant skills. And the English level is English at B1. Tradable points, it comes in because of the salary, and they would also need to meet the health and care visa requirements. So an important points to note here is that health and care visa applicants and their dependents benefit from the reduced visa application fees, and they're not required to pay the immigration health surcharge. So they're eligible for an expedited visa process, which is great, and it's very necessary right now, considering obviously the fact that there's a large need. There's a huge gap in the market for care workers in general in the UK right now. Another thing is that private households cannot sponsor skilled workers unless they are sole traders, they have their own business, and they're sponsoring someone to work for their business. So they don't have to be a registered company or anything like that, but they would need to be hiring someone on the basis of their business, not on like a private or domestic need. So though there's not a requirement for professional qualifications, you still need to provide evidence of the appropriate skill level being met. This can be done through references, it can be done through past experience, or for other employment they used to have. And finally, the changes that are being introduced are temporary. So at the moment, they've said they've implemented them for 12 months, but this may be extended. It's likely it will be extended. It may become permanent, who knows? But at the moment, they've said it's only for 12 months. So it's recommended that if it's something that people want to do, they should try and get in on it sooner rather than later. Right, so that's most of the information in terms of sponsor licenses and hiring a foreign worker. Moving on, we're looking very shortly, I don't want to go into too much detail on this section at the moment, but looking at sponsor duties and compliance. So there has been a lot of guidance that's been issued by the Home Office about skilled worker route, about sponsor licenses, etc. And the sort of part 3 that's been issued is sponsor duties and compliance. Now, the most recent update was on the 15th of February, following the statement of changes implementation. But there's a lot of other information that's also out there and that is also being constantly updated. However, sponsor duties and compliance is very important because it puts the employer at risk if they are not following their sponsor duties in terms of what happens to their workers if they are not complying. Okay. I'm going to go through these just not in too much detail because there's a lot, and I don't want to just sort of I'll go through it a bit more generally at this stage, but I'm happy to discuss it further later. And also, we are planning on doing a specific sponsor duties and compliance webinar that goes into more detail on this a little bit later. So we'll let you know about that if you'd be interested to attend. So just the background. The first thing that you need to know is that when a sponsor is given a license, they are given a rating. Okay. If you're successful, you get an A rating. So this is the highest rating, and it's given to trusted organizations that have been approved. They show that they've got the necessary systems in place to comply. They have the correct HR manager or authorizing officer person to take care of not just their employees in the UK, but also their foreign workers in specific, to make sure that they're working in the right place, getting paid the right salary, etc. Now, the sponsor has to maintain their systems and policies in order to maintain this rating. The sponsor license is granted for 4 years, and after the 4 years, you do need to reapply. It is a simpler process than just than the initial application, obviously, but they will do checks at this stage. However, you need to keep on top of your licenses throughout the full 4 years, because if they find out at the stage of you reapplying that you've not complied, then obviously this could hurt your chances of getting a renewal of your license or keeping your A rating. Okay, the Home Office is able to reassess at any time during compliance visits. They could just rock up to your business and ask to see your records to make sure that you are complying. And if you are unable to do that, then obviously there can be consequences. So if the Home Office finds that a business has not been complying, they will be downgraded to a B rating. Now, when you have a B rating, you're technically kind of on pause. You're not able to keep functioning as a license holder. You will need to meet a time-limited action plan to regain the A rating. So you'll have to show the Home Office that this is what you're going to do, what steps you're going to take, and in what period of time to basically comply with the Home Office properly again and reinstate your A rating. If they cannot meet these requirements within the time limit, then your license will be revoked, which obviously you do not want. The Home Office can suspend or revoke your license without taking steps to first downgrade. Okay, so you could be, going from an A rating to just a complete revocation. It does depend on the seriousness of the breach. A point to note about downgrading as well. If you are if you have a license revoked, there is a cooling off period before you can reapply for a sponsor license. So you need to just be really careful about this. And it is also difficult to appeal against the Home Office in terms of revocations. It's there's not been very many successful cases of appeals when it comes to appealing a revocation. So in terms of the general sponsor duties and compliance, there are a number of duties, okay, which include things like reporting, record keeping, complying with immigration law and sponsor guidance, and also complying with wider UK law, which includes employment law. You must also not be engaging in behavior or actions that are not conducive to the public good. A failure to comply means that your cost, your certificate of sponsorship allocation could be reduced to 0, so you can't actually allocate any certificates. You could be downgraded, which I mentioned already. You could have your license suspended or revoked. And you could also be reported to the police or other authorities for non-compliance. This is a list that I'm not going to read through, but it's here for you to look at. But these are changes that must be reported within 10 working days. So these are, if there's significant things that happen within your organization or with the migrant worker, you need to report these very quickly. This is done through something called the Sponsor Management System, the SMS, which you will have access to as a sponsor. And this needs to be sort of a constant communication with the Home Office to make sure that they know what's going on, they understand what's happened. This list is the main points. There are a few more as well, and it's always good just to make sure that you're aware of those. An example is, for example, if the sponsor worker doesn't start the role, which they're meant to be doing within, on the designated day that they're meant to start. This also has to do with, for example, if the organization itself that sponsors workers changes management or changes their actual license or the actual registration because they're taken over by a different company, for example, or there's a new set of shareholders or things like that. These need to be submitted to the Home Office very quickly so that they're made aware of the changes. Other changes need to be reported within 20 working days. So these are a little bit less serious, but still need to be taken into account and still need to be reported to the Home Office so that they're made aware of whatever changes they might be. So, if there's changes of business, a change of business name or change of location, etc., all these things need to be told to the Home Office so that they're made aware of any changes. There's also a list of documents that in terms of record keeping, not reporting anymore, in terms of record keeping, these are documents that the business needs to have on hand at any time, and they must be constantly updated. So if the Home Office does come for a compliance visit, you can just pull out everything and say, yep, everything is right here. I've got a copy of all these things, their current passport, BRP, their address, when they arrived, their contact details, absences, anything. So all those things need to be provided in case the Home Office does show up for a compliance visit. You can say, yes, I know exactly what's going on with my worker. I know where they are. I know what they're doing. A few other considerations in terms of record keeping. These records should be kept throughout the sponsorship period, either until 1 year has passed from the date on which sponsorship ended, or the date on which a compliance officer has examined and approved them, if this is less than 1 year after the sponsorship ended. Okay, so you need to keep these things on file. It's obviously a data protection thing as well. Being aware of that. and retaining any specified documents in terms of right to work checks, and or in terms of the application itself that was made for the sponsor license, etc. It can be also kept in a paper or electronic form. We often recommend to do both, just in case. Finally, just a few final points on compliance. So in terms of UK immigration law, the employer themselves needs to be a reliable and genuine employer. So they should also be complying with things like employment law, national minimum wage and paid holiday entitlement, planning permission, food standards, DBS checks, health and safety, all that sort of stuff should be kept up to date. They should be running this as a genuine and reliable business. The SMS system, the sponsor management system, needs to be used by the authorizing officer. You can also appoint sort of other key contacts which can access the site, but to make reporting changes, etc. But they don't have the same full user ability. You also need to make sure that this is kept up to date with contact details for the business and the migrant worker, and the location of the business premises where the migrant is working. So be that at the main office, at a branch, at a residential place, depends. There's also been a lot of working from home, but they need to be up to date on those things. There's also things involved with insolvency and also with mergers and acquisitions, including complete or partial takeovers and 2P or transfer undertakings, protection of employment considerations under the regulations in 2006. Okay, so finally, just a final point to go over. There's a lot that goes into business immigration. It goes into sponsorship and hiring skilled workers, not just the initial applications, but how you carry the business and the sponsorship over the 4 years and beyond. So it's very important to be aware of those duties, and obviously to make sure that you're doing the right thing at the right time and not missing anything. So if you feel that this is something that you would like to go into or you're looking at, we're very happy to assist you on this as well. We are able to assist you at various stages. At the initial application stages of acquiring a sponsor license, of renewing a sponsor license, also in terms of compliance checks and pre-license interviews. We can also help with business audits and record keeping checks. So, coming and doing a sort of a mock compliance visit as a home office officer to see how you would stand up. Also, obviously, the actual hiring of the migrant workers and applying for skilled worker visas, not for them and also as for their dependents or family members. Also, we can assist if you are looking at reinstating an A rating following a downgrade to a B rating. So we would be very happy to discuss with you if that's something you are looking to do. So that is the end of our presentation, and we're very happy to take some questions now if anyone would like to ask anything. Oh, thank you, Anna. Okay, Anna's just asked at what stage and how does a sponsor need to pay skills surcharge? So this is done at the assigning of the costs of the certificate of sponsorship. So this is when you apply for a cost, you would do this usually through the SMS, so through the skills management, the sponsor management system. And this can be done then through basically once you apply for one, you get one, and then it's assigned, you would pay for the skills surcharge at that stage. Yeah. Good question from Sheikh. Yeah. Can an immigration advisor be a key contact on a license application? So the answer is yes. Okay. Usually they would be at the level 1 user stage. You couldn't make them an authorizing officer. It's just impossible. The authorizing officer has to be obviously the actual someone in the actual business and familiar with the business. But yes, an immigration advisor can be a key contact. That's not a problem. They would be assigned after the license is granted. But yes, often many immigration advisors are key contacts to help with actual management things after the license is granted. Yeah. And Anna is asking the question, how soon do they usually assign a cost? So you do have to apply for a cost through the system. And to be honest, they're quite quick. So as long as all the information is there and there's nothing outstanding that they don't request for anything else, it can be done in a couple of days. There has been a little bit of delay in terms of backlog at the moment, but generally they are quite quick as long as everything is there that they need to see. Yeah. Thank you, Anna. Thank you for joining. We are very happy to assist with these sorts of things. If you do have questions, you can get in touch with us. Our contact details are on screen. And we'll also be hopefully doing a few more of these. So if you have other people who are interested, or maybe they're just the sort of initial stages of making their licenses or whatever, and trying to look into it, then obviously feel free to get in touch and be happy to assist. Tajmal, further to key contact matter, does that mean that during the pre-license stage, legal reps won't have any contact with the Home Office? I'm not quite sure what you mean. If you could maybe elaborate on that question. Before a license is granted, there isn't much contact with the Home Office. That's true. In terms of like, if, for example, you submit the application and then they ask for further details, legal reps are able to communicate with the Home Office on behalf of the business, as long as the business has informed the Home Office that the legal reps will be assisting. Something that is very crucial, though, is that legal reps are not able to submit the application on behalf of the business. So the business, even if the legal rep fills out the entire application for them, they cannot submit the application. It must be done by the business itself. But in terms of communication or contact, they can contact the Home Office on behalf of the business as long as the business has informed the Home Office through their submissions that this is the legal rep who's helping with this situation. Yeah. Thank you, Shaukat. How much do you charge for applications for sponsor? Our fees at the moment, we're sort of going through a restructuring a bit. But if you would like information, obviously, on that, we'd be very happy to get in touch with you. If you send us an email to this, oh, thank you, Tajmal, that's great. To this email address, inquiry@cpclaw.co.uk, then we can get in touch with you. It also does depend, obviously, on how much work is involved. If it's a larger business, a smaller business, how many employees you're thinking of taking on. So it would be good if you get in touch with us first, and then we can let you know, sort of our fees in that regard, if that's okay. Ooh, good question. Okay. Question from Naeem. Can a legal rep be present when the Home Office attend the business to ensure compliance with the organization? To be honest, I'm not quite sure on that question. I'd have to look into it. My feeling is no, though, from past experience. I think you can obviously assist the business before the Home Office is going to attend, if they tell them, because they might not tell you, they might just show up. But from what I know, they can't show that they're doing stuff, because in terms of the actual compliance, record keeping, and management of the foreign workers, that cannot be done with a legal representative. All of that must be done by the authorizing officer. So the authorizing officer needs to prove that they are able to do that on their own. So I think, they could maybe be in the building, but I don't think they could ever be interacting with the Home Office in that way during a compliance visit. And to be honest, probably it's best if they weren't there, if they just sort of let the business get on with it. but obviously provide all the resources to the business to make sure that they would be able to pass those compliance checks. Yeah. Okay, Sheikh. Can a legal advisor send supporting documents from their own email address, and can application registration email must be authorizing email? Okay, so it's two questions in here. First question, can legal advisors send supporting documents from their own email address? The answer to that is yes. Okay, again, as long as they have been informed, as long as the Home Office has already been informed by the business, by the authorizing officer, that the legal advisor is helping. Okay. The second question, can application registration email, must that be the authorizing officer's email? The answer to that is yes. They cannot use the legal advisor's email for the registration email. It must be through the organization. So the authorizing officer needs to be one of the key individuals in the business who has access to all of the employee records and is able to keep an eye on employees, and they must be the one to register. Okay. Then after that, once everything is submitted, further submissions and communication can be with the legal advisor's email as long as they copy in the authorizing officer. Okay. And another thing to note is that the legal advisor does need to be, a certified legal advisor. So either through the SRA or the Bar Standards Board, or through OICS. Okay. So it can't just be sort of like someone who knows the law a little bit. It needs to be someone who has actually, worked in a legal practice and is properly able to give them legal advice. Okay, another question from Naeem. Is the skills surcharge payable at issue to the foreign worker or when the foreign worker's application for the Tier 2 visa is accepted by the Home Office? It's a good question. From my recollection, I would need to check. So I don't want you to take my word for this at the moment. I'd like to go away and I'll get back to you if that's okay. But I believe it is payable at the beginning. So when it's when the cost is issued, when the certificate is issued, because there's a step process in terms of applying for a cost, receiving the cost, so then being issued the cost, and then assigning the cost. So the cost needs to be assigned to a specific person, and then that person will then apply for a visa. And it would be the skilled worker visa now. And from my recollection, there's no further payment at the skilled worker visa stage, apart from the application fee and the immigration health surcharge. So yes, the skills charge is paid earlier. It's paid when the cost is issued. Yeah. Yeah. Sorry, just I'll read that one out as well. Is there a discounted fee for the cost and skills surcharge for charity organizations? There might be a discount, but I'm not sure, so I wouldn't say yes to that at the moment. What if level 1 user and authorized officer cannot speak English at the interview stage? Okay, that's an interesting question. I've never come across that, to be honest. There is a possibility that a translator can be used. I haven't really looked into that. Definitely something to think about. Again, we're taking a note of all of these questions. So what we can do is obviously send you feedback to look into if that's okay. And I would suggest as well, if you do have more questions, I think, Naeem, you've been very active, which has been great, obviously, to get lots of questions. But if you have other questions, then feel free to send them to our email, and then we can go through it that way as well. I'd have to look into that. That's an interesting question, though. Yeah, I hadn't really thought about that, because there is obviously the English level requirement for the workers. I think there would be a need, though, obviously at the, in terms of being a a reliable business, and being able to function and work with the current workforce as well. There might be something to think about there in terms of the ability to manage the workers, all of them, however many employees that they may have, in the English language and another language. So I think there would be something to think about there. I don't recall seeing guidance on this from my research, but I'd be happy to look into it and see what I can find, because I think that's quite interesting in terms of the question. Okay, Shaukat Ali, the person on a business visa who has no sales status in the UK can also apply for sponsor license if needed to employ some experts from outside the UK for expansion of the business. What kind of business are they? Are they operating as like an overseas representative? Yeah, I think again, it would be a situation of being a genuine UK business. So a business in the UK, because that's one of the eligibility requirements when you are applying, is that you are a business functioning in the UK, you have a base in the UK. So if it's a functioning business in the UK, even if that person's on a business visa, if the business is registered, if the business is operating genuinely in the UK, then yes, they would have to apply for a sponsor license. Yeah. Because they would be sponsoring foreign workers. Yeah. If they were looking to employ locals, then it wouldn't be needed in terms of experts. But if they were looking at foreign experts, then it would be something to consider, definitely. But it would be a case of checking the suitability of the business itself as a genuine business operating in the UK. Because it would be the business itself would be applying, not the person. If that makes sense. Okay, can the business owner sponsor a foreign worker who is their relative if the business owner is not an SMS user? It's a little bit confusing, unfortunately, that question. So you cannot sponsor anyone unless you are an SMS user. You can, a business, someone who owns a business can hire a relative as long as there is a genuine need for that person. Yeah. So, let's say there's a business that specializes in, I don't know, making shoes, let's just say, and the business owner's brother is an expert in their country at making shoes. If they want to bring their relative to grow the business and there's a genuine need for that person, and that's the best person to hire because they know their skills, they know their background, their expertise, etc., then that would be fine. But the business needs to still be, they need to have a sponsor license. They need to have a sponsor license and be able to hire foreign workers to be able to even start that process, if that makes sense. Perfect. Okay, well, I will leave it there. I'm going to just turn off the recording for now, but I'll hang around for a couple more minutes. If people do have any other questions, feel free to get in touch. If not, thank you very much for joining. Hopefully you found it useful. And as I said, if you have other questions, please get in touch by email. And yes, thank you for attending. It's been great to have you. Hope you have a very nice rest of your afternoon.